My name is Siamak Riyahi. I'm the CEO and founder of Riyahi Patents. Um, I'm going to provide you with a bit of a description and background about the company, and then I'll leave all the technical matters to Vivek, and he's the expert in the field for that. Riyahi Patents started in Canada about 6 years ago, back in 2018 in British Columbia. And prior to that, the company was based in the US and started in 2012. So it's been around 12 years that we are in intellectual property business in North America. And a few years later, I would say 2021, we expanded to Ontario. And then recently, we expanded to Atlantic region, to Calgary. And we were fortunate to work with Northforge a few months ago. And we work with primarily startups. We have 67, 68 startups in our portfolio that we manage their IP portfolio. We do everything IP related for them. And we work with 12 to 14 SMEs, small, medium sized enterprises under IP matters. So, give or take, we have 80 something clients that we handle everything related to intellectual property matters. We also help those startups with securing any intellectual property grants or funding if needed. And as they grow up, we also grow up with them and build the IP portfolio for them, and then help them with their M&A, mergers and acquisition, hopefully in a few years when the startup is ready to exit. Without further ado, I leave it up to Vivek to go over the presentation for today, which is prior art in landscape and freedom to operate, some of the services and some of the things that are very essential and necessary for many startups and SMEs prior to filing a patent. And as Nerman provided information, after that, we are ready for Q&A and networking and all that. Thank you.
Thank you so much, Siamak. Hello, everyone. My name is Vivek Katyar. I am CTO and co-founder of Riyahi Patents. As Siamak described and about the services that we provide, who we are. So I'm starting the presentation where we will discuss many things about patents in prior arts. Okay, so today's session is primarily focused on power of prior art search and landscape analysis. So first we discuss about what is actually prior art search, and then we deep dive into landscape analysis. I think Siamak already explained who we are, what we do, but I just want to add a few more things. We specialize in funds and grants especially related to IP. We help clients to curate, like identify all the funds so that we help help them with the application process, what are the criterias, and guide them to get selected for these grants. Once they are selected, we work with them. We help them to build an IP strategy for them and file patent trademark as needed. We work with Company Tech, Northforge, New Venture BC, Springboard, Innovate Calgary. So we are working with most of the Elevate IP program providers in Canada. We also work with IPON. We also work with IRAP for Elevate IP. So this is what we do. This is our team. We are not just patent lawyers and attorneys. Our team is of IP consultants who most of them have I would say masters and PhD in science and technology. So it's a rich team with the experience or diverse field of experience in diverse field, not just patent lawyers. So here is agenda for today's talk. First is we deep dive into what are prior art searches and how does they impact overall IP strategy for the company, and then the importance of identifying prior art. What is the freedom to operate analysis, and next what are landscape. So let's go into the definition. By definition, what are the prior arts? Prior arts refer to any evidence that that is known before filing of a patent application. So let's say you have an idea, you want to file a patent application. So if there is anything that is related to your invention or your idea that you are going to file a patent application, anything related to that is called a prior art, and that could harm the patentability of the invention. So any document, any written document, any patent, any material that could become evidence is called a prior art. Here are some examples. As I mentioned, the patents, published patent document, application, journal articles, books, product in the market, public demonstration, anything, any evidence, in the books in the library, they are also can become a prior art. What's the importance of the prior art? We will discuss this topic in detail in this during the presentation. But understanding the prior art is very crucial for determining the novelty and non-obvious. We will discuss these both term novelty and non-obvious in detail in the next in the coming slides. But overall, I just want to mention that understanding the prior art is really, really crucial to get a patent. um, as we described, like as I mentioned, like there are multiple kind of prior art. So patent literatures, patent document, like patent document, patent publications, these are prior art. Non-patent document, like any research paper, published document, even blog post, online content, anything can become a prior art. And these are the examples. And any public sale of a product, let's say these iPods are on sale, this is a prior art for any related or relevant invention. Anything demonstration for sale, even the product is not in the market, if they say the product is coming in next few months and they are demonstrating it on their website that's coming soon or something like this with certain features, it can become a prior art. So how to identify these prior art? There are multiple tools to identify these prior arts, but there is no such tool that you can identify all type of prior art in one place. For patents, there are specialized tools where you can perform the search and identify relevant patent. There are some databases, like maybe many of you are aware of these non-patent databases. Google Scholar, it's very common. Whenever you type on Google to search for any research paper, it redirect to Google Scholar. So it may be like so Google Scholar is one of the most well-known, I would say, the non-patent document search database. And then IEEE Explore, ACM, PubMed, and many more. There are multiple kind of patent databases that exist. Some of them are specialized in different fields. Some of them are very generic, like Google Scholar. Patent databases, some of the databases are like free databases where you can perform the search. Google Patent is one of the, yeah, it's well known to identify to perform basic search. You can identify patent document all around the world. It's not, it's not that strong in terms of searching, although it has a like huge repository of documents, but structured searching is not that efficient, I would say. There are country-specific database. So most of the countries, patent offices of the countries, they have their own database to perform the search. U.S. Patent Office has their database, USPTO, EPO, European Patent Office. WIPO had the International Patent Applications database. Canadian database, CIPO, is the Canadian database where you can do a quick search, like with the keywords, with numbers, maybe some of the like basic search with the classification. There are certain specialized tools that are used by professionals to identify a patent document with a very strategic manner. So Questel Orbit is one of the database. Mindsoft Petbase is a database. Quartet is one of the database that is really emerging. It's a good tool for performing structured search. There are certain databases that use AI and ML technology to identify prior arts. So Quartet is one of those databases. With In those databases, you can perform keyword-based search classifications. Okay, let me describe what the classification codes. All patent documents, like patent documents all around the world, they are classified in certain classifications. So if you know the correct classification in terms of technology area, you can perform the search and narrow down the search with some of the relevant keywords. Inventor name, if you know. Assignee name, assignee means the owner or like the company name. You can perform Boolean operator search, citation search, backward, forward. There are different strategies. I would say patent search is an art. So at the same time, science at the same time, because you need to understand you need to understand the technology, and then you need to know all the different combination, permutation and combination of the keywords, different synonyms, and combination of keywords and classification codes, inventor and assignees. These searches are done by specialists, and REI Patent, we have many specialists who have experience in various fields in technology, who can help you with these specialized searching in any domain, in any technology domain. There are like in last 4 or 5 years, I would say there are many AI based databases. They use these databases. They try to understand the semantic, not just the syntax, but the semantic of the invention, and then try to identify a relevant patent or prior art, I would say. Prior AI-based databases are strong, but we cannot fully rely on AI databases right now, because their models are not that mature. Sometimes they may not be efficient in providing the accurate results. So we follow both approach. We perform search based on keywords, classification, inventor, assignees, Boolean operators. But we also follow the AI and databases to complement each other. Okay, let's discuss about how prior art can impact the patentability of the invention. So there are certain criterias. Based on that, your patent is allowed by any patent office around the world. So these criterias, your invention should be novel, non-obvious, and useful. So obviously we cannot prove the usefulness with the prior art, but novelty and obviousness, we prove that based on the prior art analysis. Let's say we identify prior art. Any invention could be proved novel based on the prior art references that comes after the prior art search. Non-obvious analysis. Invention should be non-obvious based on prior art references. Let's say somebody invents something that uses wireless technology, but there are patents that exist in the market that describe the same type invention with the wired connection. So in some cases, I won't say that wired converting any new technology from wired connection to wireless will not always be patentable, but most of the cases, examiner may argue that it was obvious for any person skilled in the art to understand that this invention could operate in a wireless based on the technology development. So prior arts. These are the impact of prior art in terms of novelty, non-obviousness, and then claim scope. Based on prior art search, you can limit and decide the scope of the claims. Let's say you already know about any prior art. You can limit the scope of your invention that you're going to file based on existing prior, so that you can avoid those. Your invention is still novel and non obvious based on that prior art. How we can use the prior art in IP strategy. First one is freedom to operate. We discussed this topic in detail in the coming slide, but first let me touch base on that briefly. Uh, let's say you find out some prior art that your invention or your product may infringe in that particular jurisdiction. Let's say during prior art search we identify a patent, a Canadian patent that talks about that the similar thing that your product is doing. In that case, you may be infringing on that Canadian patent in Canadian market. So, and patent drafting. Next, if you already know about existing prior arts, then you can draft your patent in a way that you avoid those prior arts. If you avoid those prior art, it means you are strengthening your patent. So it can improve, prior arts can improve the quality of the patent based on based on the research. Competitive analysis, you can identify competitors prior art and guide your R&D in that direction and IP filing strategy. Let's say you know a competitor, you identify all the prior arts, all the prior art patent, or I mean blog post or research paper, and build your IP strategy around that. You file patent in those areas where they don't they missed out. You fill those gap and have create a patent portfolio. So in the case when let's say your patent might be infringing on some of your patent, there may be situation that their product are infringing on your patent, so that you can design a strategy that you can get a competitive edge over your competitors based on prior art filing, patent filing. Portfolio management, you can assess the value of existing patent based on newly found prior. So the one of the examples could be, let's say your competitor comes to you and they ask that there's a portfolio that you might be infringing, but if you identify prior art for those patents that your competitor is coming with, you can say these patents have no value. So you can assess the value of his existing patent art based on newly found prior arts. So how to manage prior art searches, regular monitoring, collaboration, documentation. So I would say always consult with like an expert, a patent attorney, IP consultant, R&D team, so that you list down all the prior arts that exist related to your technology. You have all those documented, and do a prior search in every 9 to 10 months, so that coming patents you have the knowledge of those patents. Why I'm saying this, every time, like let's say you file a patent today, uh, it won't be published at least a year, right? So that way, if anybody files a patent, that won't be published. That's why I'm saying you need to perform a prior art search in every 8 to 9 months, so that you can identify all those patents that are filed a year back. You can identify those patent documents. Importance of identifying prior art for patentability: you can ensure the novelty of the patent. You can avoid rejections. You When you already know prior art searches, you can modify your claims in a way that you have high likelihood of not getting rejections based on novelty and obviousness from the patent office. You can make strategic filing decisions based on prior art. If you see that there are not many prior art in particular domain, you can steer your invention in product development or inventions R&D in a way that you can make more filing decisions. Importance of checking the patentability. So first, discuss assessment of novelty and non-obviousness. We can detect prior art searches that whether this prior art like become threat or non-obvious threat. Then influence the claim scope. Once if you know the, you can manage the claim scope. So the claims are of your patent. Whatever is in the claim is that part is only enforceable. So there are two ways how you use your patent. First, to stay away competitors. So if you have the can protect your product, but you can also generate if anyone is infringing on your patent. And if you have broad claims covering the many covering multiple variations of your invention or of your product or through the patent, you can find infringers. You can get money by licensing, cross licensing. So there are different ways where by that you can generate revenue. That's why claims scope of the claims is very, very risk management. Relevant prior art, you can mitigate the risk of future challenge of patent validity. Here is one more thing that I want to emphasize. Patent office, like it's not patent office duty to enhance or enhance the quality of your patent. Their duty is to examine the patent. They will examine based on the invention that you provide, based on the claims that you provide. They try to identify prior art if already exists. If not, they will check allow it. But whether any commercial value or not is up to you. How you draft the claims invention, and at the same time that we could prior art the patent is really, really in hurry. They don't have much time. Such claims that are actually not. So um, the prosecution time, and time is money. If we minimize the prosecution time, obviously that there will be less to and fro. You can save the cost, time. Your patent will be allowed in less and less time. That's why prior art search is so important. This is a process that we follow at Reahi Patent before filing a patent. So here you are, you have an idea, you come to us. So we discussed what's idea, obviously before, after signing an NDA, we discuss the idea, identify, okay, what's the potential for that. And we ask you to provide all the features of the, once we sign the contract and decide to start work together, we we ask the inventive features of the product or the invention. Then patent expert or analyst in our team, they perform a thorough search, generate a report. Report is kind of one-to-one mapping of your inventive concept to all the patent or non-patent document exist, all the prior art searches that exist. We generate a kind of heat map. Based on that, we provide an informed decision to you that what the potential of getting a patent. We may say there are less chances, then this is the opportunity for you to improve your invention. Maybe you want to add certain more features that are actually novel. Then once we identify all those, we work on the report, we settle, and then we hand over this report to our patent attorney. They draft the patent and share this with you, so you can review the patent. If you have any comments, you can add those comments. And once this is finalized, patent application is finalized, we our patent attorney, they file the patent application. Patent examiner, they examine the patent. If they have any question, they ask, our patent attorney answer these questions. And once patent examiner is satisfied, patent is granted. So I was talking about this particular to and fro. If examiner have many questions, they ask like many questions, why this, why you think this patent should be allowed, this claim scope is too broad, or this is not allowed, something like this. So if we have prior art report ready and we draft the patent application based on this prior art search report, we already know existing prior art. We design the claim in a way that we avoid all those references. Examiner may come up with certain prior art search results, because yeah, it's their job to perform patent search. Most of the time these are all the already references that we already have in the report, but sometimes they may come up with certain references. They ask that why you think these are valid based on these claims are valid on these references. Our attorney, they provide the answers, and generally in very few communication, these patents could be allowed. So this way prior art search reports are really helpful. This is the timeline, process timeline for any patent application that we do. First, we perform scoping meeting, then we go for information gathering, feature extraction and validation. It takes 3 to 5 days for identifying and finalizing the intake form. Once intake form is ready, we perform search and analysis report. Once report is ready, we share the report with you. You review the report. If you have any questions, we answer those questions. Or if we need to, let's say if we find in the report that there are certain certain areas that we need to improve before going into patent drafting, we discuss with you. We collect, we may collect some additional information from you, and then we also provide a kind of competitor analysis in the report that we share with you. And then we go into drafting. Once the patent is drafted, you review, and then we file the patent application. So the whole process, if we are prompt, like whenever we ask any question, we are when we start collecting information, you are prompt, then we can file the patent application in 4 to 6 weeks, depending on where you want to file. Okay, now let's discuss again the prior art. I was talking about the claim quality. So prior art can help drafting stronger claims. If you already know what are the prior art you want to avoid, so you write the claims in a way that you avoid those prior arts. It means you are filing stronger claims. Um, Redundancy could be avoided. I won't say that it happens with small organizations, but honestly, it happens with large organization. I worked with Microsoft like around nine and a half years. So there are multiple teams. We saw this very often, that many teams, they were working on the similar ideas at the same time, or maybe in the different time periods. So we know this way, if we do the proper prior art search, proper assignee inventor search, we can easily identify that we are going to file the redundant claim. So that way we can save the cost for you, because there is no point filing the similar patent. Either it would be rejected, or there is no point having the similar similar patents with the similar claim scope. Defensive patenting, based on prior art search, we can file a defensive patent that sometimes we know that based on the prior art we will not get a patent because there are many prior art exists there, but we still file the patent so that our competitors, they cannot get the patent on the technology, so we are freely to operate. How we can improve the patent quality. Obviously, if the claim precision is improved, prior art quality, patent quality is improved. Validity of the patent is improved if we already know all the prior art and we already steered through the avoided all the prior art. That way, we can strengthen our patent and validity of the patent. Broadening the claim scope, we can also broaden the claim scope based on prior art. Let's say we sometimes some like the inventors, I would say startup founders, many times we hear that they want to file the patent just to patent the product, well, protect the product. It's not, there may be there are chances, or there may be the chances that you can get a broader scope based on prior art. So let's say there is a mobile device or mobile application that you want to patent. You may just want to cover the features of the product, but based on prior art, we identify there are no such features exist in the in such type of product exists in the market, and even the features related to that product that does not in the that don't exist in the market. So what we can do, we can broaden the scope in a way that the potential patent that we are filing not only protect your product, but also covers many I would say related ideas or related product ideas. So that way we can broaden the scope of the patent. Um, I think we touched on this, like how proactive claim adjustment can help in patent prosecution. If we already know about the prior art, we can make the adjustment before even filing the claims, or maybe during the prosecution, so that that can help you in avoiding reducing the office action and reducing the cost. Okay, so next topic is next topic, like after the patent infringement, is freedom to operate analysis. But first, we want to understand what is infringement. Infringement is any unauthorized use, manufacture, sale, or importation of the product, invention is violation of another patent right. So the patent law says any make, use, offer, sale, or offer to sale of any patented invention could be unauthorized make, use, sale, and manufacture of manufacturing, selling, or offering to sale of an invention could be a patent infringement. So how this works? Let's say what's the definition of make? You are creating a product. You are creating a product that is already patented by another company or another assignee. So that is infringement. Using the patent. So let's say you are employing the patent invention without the permission of the patent owner. Selling a product that is patented by the technology is patented by someone else, or importing, bringing a product in a country bringing an infringing product in a country, it could be without the permission, could be infringement. So there is an example. Let's say a company A holds a patent on a unique type of wireless charging technology for a smartphone, and another company starts selling or producing a smartphone and starts selling it with the same wireless technology without the authorization, without the licensing. It is an infringement. How you can avoid the infringement? One thing, perform search and analysis, conduct freedom to operate analysis to identify if there are any infringing patent. Let's say if you are the company A and you want to sell the smartphone with wireless technology, you need to know all those patents that have the similar wireless technology patented. So identify all those patent, analyze the claims of the patent thoroughly, try to identify like understand that whether you are actually infringing or not. If you are infringing, then there could be multiple ways. First could be you want to invalidate the patent. uh, and another way could be, if you cannot invalidate the patent, you want to identify what the licensing opportunity, if you can license that from the patent holder. If not, then there are different ways we will discuss in the next slides. So yeah, I mentioned the freedom to operate. So what's the freedom to operate analysis? So as I mentioned, the patent gives you the right to stop others from using a protected invention, but does not allows you to use it yourself. The patent law says patent gives you the right to stop others from making, using, selling, and offer to sell the invention. So, but it does not give you the right. It's funny, but it does not give you the right to use and sell, but it is inherent in the patent law. So freedom to operate analysis give you the ability to carry out the particular commercial activity without infringing on existing patent of others. So you want to sell a product, perform freedom to operate analysis in that particular jurisdiction. Let's say you want to sell the product in Canada. Obviously, you will be infringing only Canadian patent. You cannot infringe the patent in US because you are not selling your product in the States. So perform freedom to operate analysis for Canada. Identify patents. If there are any infringing patent, then design the strategy how you want to avoid these legal obstacles. As I mentioned, there could be strategies said that you want to license the patent. You can purchase the legal right against the for the patent. There could be other ways, like I mentioned in the previous slide. There could be design around. You can design around the claims. You can modify the product in a way that you avoid all the potential prior arts that exist. So how you identify all the infringing patent? Obviously, comprehensive patent search, analyzing their claims, considering all relevant patents, include not only patents in the similar technology, but also in the overlapping technologies. Sometimes some company, they smartly, what they do, they do not, they file, like the companies who have good IP strategy, they don't product they not only protect their product, they also want to capture the technology. So they file the patent, they draft the claims in a way that they are not only protecting their product, they are also there is also a scope of finding infringers, so that they are not generating the money, not only generating the money from selling the product, they are also they can also generate the money from their patent portfolio when the time comes. So you need to you need to identify all the patent documents in those particular jurisdiction using a comprehensive patent search and thoroughly analyzing their claims. Take help from like professionals, so that it is like you have the strong report in terms of like freedom to operate analysis, or if the need be, invalidity analysis report. Yeah, these are some of the strategies to overcome the potential infringement. One, we already discussed, design around. You can modify to your product in a way that it's not, you are not losing the core feature of your product, but you can maybe you can provide the same feature in a different way, so that you are not infringing. So there could be like it's a live example. So some company had the product, have a patent when, let's say, imagine there is a scenario when you type on a mobile application or a chat application, there is a dot, like three dot, showing that person is typing. There are different ways you can, many companies, they have the similar features, but the representation of that feature is very different, is different in most of the product. So they have the similar feature. Some of the companies, they have patent over that, but the representation of those features is presented or designed around in a way that they are not, they are avoiding the infringement. Licensing agreement, negotiate, if it is not possible to design around, um, yeah, you can find licensing agreement for the patented technology. Cross licensing, if you already have the patent, identify if any of the product of the competitor is infringing on your patent, you can cross license the technology. And then challenging the validity of the patent. And this is one of the way many companies use this tool to invalidate the patent in question. Let's say somebody comes after you with a patent that you are infringing on their patent. One way could be design round, another way could be licensing, cross licensing. One of the ways could be invalidate the patent. You find out the prior art that could invalidate the patent itself, or patent in question. If you invalidate the patent, it means that patent is dead. They have no infringement. You are not infringing on it. Okay, yeah, let's talk about landscape analysis. So patent landscape is a comprehensive examination of patent and technology landscape with a particular field or industry. So it means, let's say, there is a technology, wireless technology, or maybe a particular protocol being used in a wireless technology. We want to perform, and this wireless technology is very core to your product. So we can perform a comprehensive landscape analysis to understand two things. One is technology white space, and competitor analysis. As it's mentioned here, that purpose of landscape, there could be two ways we can use the landscape analysis. One is technology gap, like white space, and another could be the competitor analysis. Um, why landscape analysis so important? So we will discuss this in detail in next few slides. But first is like you can identify white spaces in the technology, so you can steer your R&D in a direction where there are not many patents exist from the competitors. You can capture the technology in those areas, and you can design your patent filing business strategy, and you can also identify competitors in a particular technology domains. So those, who are the competitors, maybe they become your collaborators also. We'll discuss this in detail in the next slide. So identifying the white spaces, with the landscape analysis, we can identify if there are certain technology areas or technology sub areas where there are no patenting activity. Nobody ever thought about filing a patent application, or there are very few patents. So this is an opportunity where you can steer your R&D and get some patent on that by just understanding if there is a scope. It's not, I won't say just blindly go and file patent in any area. Patents are expensive. It's not that just you can throw the money on anything. But if you know that there is potential in certain areas, there are gaps available, you can go and file. You can design your patent IP strategy in a way that you file patents in those areas. So how you identify white spaces. We create patent map and charts through, like, by identifying like large data set of patent. Let's say we identify patent documents like 6,000 patent families, or like 17 18,000 patent documents in that particular technology area, in that particular jurisdiction, or maybe all around the world, and try to understand where the growing market is. And if there is opportunity, let's say there is a particular technology that is emerging in certain countries, maybe any new technologies like it is emerging in China or in India. You want to steer your IP strategy in a way that you file patent in those countries before your competitor does. And then strategic importance. What's white space identification allows companies to target innovation in areas, yeah, where the I think we did just discuss this topic. Identifying the competitors, you can identify competitors based on the technology areas where they are actively filing. Analyzing a competitor's portfolio, you can analyze competitors portfolio, patent portfolio, and try to understand where they have most of their strength, or where they have weaknesses. So you may complement, like filing some patent. You may want to file some patent where they have weaknesses, so that if they come after you, you have something ready for them, for yourself, to protect yourself. Benchmarking, compare your own patent portfolio with competitors to assess what your position in the market. This is what big companies do. They do benchmarking to identify where they are as compared to their competitors. Um, Obviously, it is important for business strategy. You want to understand, you use insights from the competitor analysis to refine your IP strategy, anticipate market move, like where you want to. If you see that market is very very crowded, and there are very strong players exist in the US related to your technology, you may not want to go there. Or if you want to go there, you want to make your product in a way that you are not infringing, or you are offering something new as compared to your competitors. At the same, as I mentioned, you can identify competitors, but you can also identify collaborators through landscape analysis, because there could be some companies who are working in this, or research institution or startup that are working in certain. If you're a big company, you can identify small companies who are working in the same technology, so you may want to acquire those companies. Or if you are a small company, startup, you can identify a big company who are working in the complementing field. You may see that company as a potential for merger, like acquisition, or they may be interested in your product technology. You can work on, so like there are two companies. You may identify certain companies who are working on similar areas. You want to collaborate and file co-patent with co-ownership. You may form strategic alliance, um, evaluate synergies between companies based on patent portfolio in particular jurisdictions. What are the best practices? Effective landscapes, obviously, regular updates, landscape analysis. These must be updated in 6 to 8 months, because as I previously mentioned that patent applications, they are published, like once you file the patent application, it takes at least a year to get published. So if you're performing landscape analysis today, you will not get all those documents that are being filed right now, like in this month. So obviously, you once you perform the landscape analysis next year, then only you can identify those patent documents. You can collaborate with experts, obviously, these landscape analysis, these are the These searches are very tricky and needs expertise in terms of categorization, in terms of first searching and then categorization, and then data cleaning, lot of things, and how you need to present the data, and how to understand and generate insights from the data. Strategic integration, landscape analysis in broader business and R&D to align innovation effort and the business needs. Documentation and reporting, obviously, these are the best practices, and how you need to have all these reports ready, so that these reports not only just for your consumption, these landscape analysis report could be helpful when you're going to pitching to any VC or angel investors or any investors. So you can show them you are not just blindly following your IP strategy, you have rationale behind it. You have this landscape where there are white spaces available. These are about your competitors and collaborators. So these reports are really, really important for your IP strategy. Oh, speaking of IP strategy, so let's talk about briefly talk about IP strategy. So IP strategy is actually a blueprint for safeguarding and enhancing business value by obtaining, cultivating intellectual property right, facilitating sustained business expansion, strengthen the capability to compete on international. So all in all, IP strategy is actually a blueprint I would say best practices, how you need to safeguard your invention, how to follow like how your IP should be aligned with your business strategy. So it's not a kind of to-do list. Just check those lists and you are done with your IP strategy. To set up ongoing question that actually steers the innovation in innovation in the company. So it just these are so what are these questions? I call it 4 Ws of effective IP strategy: what, when, why, and where. What you need to protect, why you need to protect, when and where you need to protect. So first is what, whether, like, it totally depends which kind of what type of business you are. Based on that, you need to like the IP strategy should be in a way to identify what you should protect. So let's say you're a company that needs brand protection, so you need to file trademark. It's not that every company needs patent or every company needs trademark or trade secret or something like this. So through IP strategy, we can identify what type of IP asset you need, what, like how you should protect your IP asset, whether it is brand, whether it is technology, whether it is design, algorithm, consumer data, something like this. And why you need protection. You want to protect brand, obviously. If you are well known by your name or your logo, so obviously you should go for trademark filing. Technology protection, if you think your technology is innovative and you need to protect it, file a patent. For data, obviously you need to protect your data, consumer customers data, collaborators, partners data about certain multiple things, that maybe the data that you're using to train your machine learning models and something like this. Where you want to protect. So it's a good question. Like IP strategy is not like you cannot file patent in each and every country in the world without understanding like where the actual market is. There's no point burning money on that. Identify your market, current and future market, and invest on that. Let's say you want to launch your product in US and Canada, then these are the potential market there you should file the patent. And then maybe you think there is good potential for your product in Europe, then you can design the IP strategy for Europe. If you think there is no scope for your product in China, like there is no point filing a patent in China. So and next question is when. When is the right time to file for IP protection? As soon as you start working on your technology, you should go for some kind of IP protection, whether you file provisional application, very basic provisional application, protect your idea. You may not want to file for the company name or for the product name. Sometimes based on multiple tags, multiple interferences, maybe you change the company name, maybe you change the product name or logo or something like this. So at very initial stage, you may not want to go for trademark filing, but you still want to technology through patent filing. On the contrary, if you are a different kind of business where your brand matters most, then go for patent. You should go for trademark filing first. Then you can think about filing patents if there is any something patentable. So IP strategy for a business, it should be in a way like identify what you need to protect. IP should be aligned with your business. You can then the next point is IP operation, and then execution, and then alignment. So first identify what are the IP, and then develop, create an IP strategy, identify how to optimize, and then take the steps to protect or like execute the IP strategy or protect your inventions, and then alignment. So it's not over if you just say, okay, you follow the IP strategy. As I mentioned, it's not the checklist, it's ongoing questions: how, why, what, and when. So it means you need to again understand, maybe like in 6 months, okay, what's new, what you developed. Then we can go with the same circle again. Okay, what's how this new technology related to your business, and then again develop an IP strategy for that, enhance the IP strategy for that, execute that, and then file for patent or trademark or whatever, or maybe trade secret itself. Business strategy and your IP strategy should always be aligned. It's not that your business strategy is going south, strategy is going north, because business strategy is something that will be generating revenue for the company. So your IP strategy should always be aligned with that. You cannot just file blank, as we already discussed. Like, you cannot go and file patent in any jurisdiction without understanding if there is any potential for business or not. If there's no market for your product, there is no point going there and filing patent. To take competitive edge, obviously you file your business strategy and IP strategy should be aligned in a way that you get the competitive edge through your IP strategy. Market expansion and growth, obviously, and innovation enablement. Your IP strategy should be aligned, should be in a way that promote the environment of innovation in the company. So so that you can continuously improve and kind of put money for the innovation. So yeah, I think we all know this. We all know about the Elevate IP grant. So this is why we are here to discuss through this Elevate IP program. I would say there are so Elevate IP is not the only program that helps startups in Canada for their IP requirement. There are other programs too. They have some more like all the programs. They have similar kind of support available, but there are certain limitations. So considering most of you know about Elevate IP, I will brief my introduction about the Elevate IP program. So obviously everybody knows that this Elevate IP program helps startups to get funding to build an IP strategy, develop and implement IP strategy. They are helping up to 100K of money for doing so in multiple stages. There is another program. It is specifically for Ontario-based company, intellectual property of Ontario. So they are helping innovative startups or innovative companies in Ontario for building an IP strategy, filing patent and trademark, doing landscape analysis, freedom to operate analysis, filing patents, trademark. All, it's not just about Canada. You can file patent with the help of IPON. Same with Elevate IP, like you can file patent in anywhere depending on your market requirement. As I mentioned, your IP business strategy should be aligned. So yeah, they help. This fund is really generous for Ontario-based companies. You can do the research. You can become their client, submit the statement of work. They have rounds of I would say funding call 4 to 6 times in a year. So they are really generous. They support up to 80% of the cost of for all the projects. There is another program like NRC IREP IP Assist program. So this program is available through National Research Council. IREP's IP Assistant IP Assist program. They also help Canadian businesses to develop and implement IP strategy. They support up to 75% of the total project cost, but you need to first be the NRC client to leverage that fund. Can Export SME is the program. So this is the program. They help small and medium-sized businesses. They provide funding up to 50K. There are many other things, including international market development activities, including IP protection. So if you want to file patent in US, totally based on your business strategy, they help you with the foreign filing of the patent and trademark, and maybe even like IP consulting fees. IAC is another organization. I would say it's a not for profit organization. They help Canadian businesses to get funding for especially for data driven and clean tech companies for their IP requirement. So yeah, Elevate IP program is not the only one. There are other programs too, depending on your technology area and your geographical location where you are in Canada. There are various programs available for that. Okay, yeah, that's it from my side. I hope it was helpful, and thank you, Narmin. I think we are going into Q&A session. Q&A. Thank you so much.
Yes. I wish that you're prepared. We have lots of questions for you.
Oh,
So,
okay, sure.
yeah. So first, I would like to thank you for this insightful and informative presentation. Lots of useful information that every startup should know before starting their IP journey. And I like the last presentation, the last slide when you're talking about business strategy versus IP strategy. And this is the discussion that we go with every early stage applicants who wants to go to the IP strategy. We first ask them about their business strategy. And if they don't have a business strategy, we always have this discussion. You can't start an IP strategy if you don't have a business strategy. So thank you very much that you have highlighted this. So we have multiple questions. I want to be respectful to your time, Siamak and Vivek. We already past the 1 hour that we have agreed on, but it's up to you if you would like to answer the question live or you want me to send them to you via email and send me the answers. It's up to you.
We can answer some of the questions here. We have no problem. And then, yeah, if they need, if whoever asked the question, if they need more explanation, they can reach out to us directly. There is no problem.
Beautiful. Okay, so let's go to the first one. So the asking, when should a business consider using an NDA, especially when dealing with intellectual property?
I can,
Yeah,
if you want, you take a break, Vivek.
Yeah, thank you.
Taking all the hard work, so I can answer the first one, so you can take a break. Quite frankly, if they're referring to signing an NDA, for example, they're raising fund or capital from an investor of their choice, and then they want to sign an NDA. Clearly, you can sign an NDA prior to having that meeting. That's a very good strategy. But just keep in mind, not necessarily all the investors, they're going to sign an NDA and they're not obligated to do so. And keep in mind that you are asking for something, which is funding, money, investment, and all that. The best practice often is filing a US provisional prior to having those meetings. In fact, many of our startup clients, once they know that what their technology is going to revolve around, then they file a US provisional. Not only do they get a 12-month period of enhancing their technology, improving their technology, also developing the technology, but they have a priority date for that patent. With that provisional, US provisional, they can file a PCT, which is an international filing. They can go and turn it into a non-provisional US patent, which is a full application, or they can turn it into a Canadian application. So the best practice, we would say, when you're raising money and talking to investors, so you know what your technology is, so you don't really start something and without having an MVP you go and raise money. That never happens. But at that point, if you are really trying to protect your technology, the best course of action is, not only do you need to have a NDA, but it would be better to have a provisional file if you're very decisive on not being positive, not being sure that someone may steal your technology, for the lack of a better term. But just keep in mind, if you're going and talking to investors, they're going to do this sitting in meetings, and others, they're going to pitch in front of them quite a few times a week. So if they even say no to your NDA, do not get disappointed and do not think that necessarily they're going to steal your technology. If you are still a little bit suspicious or you want to protect yourself, file a provisional. More importantly, you can always say that I'm patent pending. That's also something that brings a bit of peace of mind to them, that you have protected your IP. So I hope that answered the question.
That's amazing answer. Yes, I believe that it is, was like a comprehensive answer. I love the insight that you have given in this answer. So the other question says, can you share a case study where prior art search significantly altered the course of a company IP strategy?
Um, yeah. So there are, yeah, we had a client. So we perform a prior art search, and we identified that none of the features that they provided in the first go were patentable. So it was a kind of shock to them, but at the same time it was eye opener. So what they did, they took that report. It was hard to take that, but we discussed, and they improved their product and kind of added many features. And based on the prior art references that identified during the patent search, they read all the patent document and try to understand, okay, how we can improve those our product based on that exists in the market and that not exists in the market. For that, what we did, we did not file that patent, but next 6 months we filed a patent with all the possible revisions, and that was a success.
Interesting.
If
Yes,
I
and this is one also of the discussion that we go with the applicants when we come to discuss, okay, start with an IP strategy. Don't go directly to patent, because the
Yeah,
IP strategy will reveal lots of powerful components in your business that you yourself may be degrading or maybe not aware that, oh my God, this is
mhm.
more important than whatever you thought that it is a patentable, strong part of your business.
Yeah,
So thank you for this answer, Vivek.
thank you.
If Nerman, if I
Yes.
may add something, there was another question kept coming up regarding any pitfalls about
Yeah.
patent search and landscape. Quite frankly, to add to what Vivek mentioned, there are no pitfalls for that. We can provide you many case studies that the client either didn't want to do a patent search or they didn't want to do landscape because there was cost associated with that, or unfortunately the patent attorney didn't even try to convince them, or they might have been combination of both. So there are two problems. When you're developing a technology, you're too close to it, and you live, you eat, you breathe the technology for the past couple of years before filing anything, before even talking to any investors. So in your own mind, there are pieces that you think it's very novel. You're the first one. However, you don't really know who else has worked already on it in the world. There are other things that you've done it quite frequently and become second nature to you. So you don't really see the novelty or inventiveness in those. So definitely not having a prior art search is going to backfire on you no matter what. The worst case scenario is you find out what you're working, or at least a few features that you're working on, they're not that novel. Before spending all that time, effort, and money on the patent application, and folks, keep in mind, filing and defending a patent is not cheap, it's pricey. So it's going to take probably a few years, few $1,000s, and we don't really want to get into how much it's going to cost you. So the more and well prepared you are ahead of time, the better off you would be in defending yourself and office actions. Because patent office, the examiners, they're going to perform a search, they're going to write down, reject your claims if they want to reject it or allow it. So, last thing you want is you receive something from a patent examiner that, how come you missed these prior art? And then that's an aha moment for many people that I don't really have a defense. I wish I had done this search thoroughly using a consultant or myself 2 years ago, 2.5 years ago. And we've heard those scenarios quite a few times.
Yes. And I 100% agree with you. And this is, let's put it this way. I don't know if I'm going to be fair with you, Samak and Vivek. And I believe for this point specifically, it is the responsibility of the service providers. It's yours because we as a startups, we as an entrepreneur, yeah, we are, passionate about patents because investors like this word, right? But we are not really aware of these details and these priority of the steps.
Oh,
So I think this becomes that when you go to a service provider, make sure that you're going to the right person. It's not that service provider that whatever you want, it's like a prescription for a medicine. Okay, you want to what? Patent? Here's it. So yeah, so I agree with you 100%.
100%, 100%. They need to sit down and put pros and cons of every single thing in front of a startup founder or co-founder. Number one, they're really overwhelmed with everything. Two, that's not their expertise. I mean, otherwise they would have never reached out to you as a service provider for IP.
Exactly. And this is one secret. You're gonna hate me, Vivek and Siamak, but you're online, so you cannot do anything now. So
We,
I'm just
we
kidding.
will
So
not. Don't worry
yeah.
about it. We will not.
When we discuss with the applicants, especially the very fresh applicants, I always tell them interview the service providers, prepare your questions, ask them how do you do this, how do you decide that this is mine? It's just like prepare your question. It's just like you don't go blindly, just like answering and just like obeying whatever they tell you. You have also a responsibility toward yourself. Talking about Elevate IB, maybe it's a free money, but even if it's a free money, invested in the right way, not in just whatever for whoever on whatever, right? So thank you very much for this really amazing answer so far. So the other question, again, I just want to check the time. So we are now 15 minutes ahead of time. Are you still okay to just like proceed with a few questions?
Yeah, 5, 6 more minutes. I think, Vivek, we should be fine, and then we can. Thank you. You put our LinkedIn profiles there. We can provide an email in the chat if they want to reach out to us through email. That's also a
Yes.
possibility if you think that.
Perfect. Yes. Yeah, after this session, once the recording is ready, I usually send like a thank you for all the audience, and we share your emails, your
Perfect.
biographies, and we share the recordings. And if you allow, we have multiple people asking for the presentation, but it's up to you. So
Yeah,
we
I can
share,
share
Yeah.
that. No worries.
By all
yeah, we
means.
share the resources with them, so they're going to be having your email as well.
Yeah. Perfect.
So the other question is, how do you foresee the role of AI and other advanced technologies in enhancing the process of a prior art search and landscape analysis in the future? However, what are the threats?
Okay, it might be shocking to many of the audience. Currently, we're using search tools that are using AI and machine learning and all that. So it's not a threat, to be honest with you. The AI and machine learning has helped patent and trademark market and industry significantly. You will be surprised how they've been helping. We have a IP advisor, Dave Hunt, with Ensemble IP, and they have a tool that they've developed as a quartet, which we are using. Believe it or not, one of the issues many years ago was um, people were becoming very innovative. Instead of saying that a mobile or a cell phone, they would have been really inventive, and they would have said a digital device which has a screen, which has some electronic parts, it's got a speaker, it's got a microphone. So, practically speaking, literally, they were referring to a mobile or a cell phone. However, they were refraining from just saying, this is what I am trying to, name it cell phone or anything like that. So the issue with that has been somewhat resolved with AI, because now the AI and machine learning algorithms, they dig into technology and find out not for the words but also for the concept behind it, and that has helped us significantly. Even if you think the role of a patent analyst or technology or subject matter expert, SMEs, they're going to be diminished, still the best patent analyst or subject matter expert can use that AI model or tool in order to perform the best search and analysis. We have a tool developed in house in our company. Our software developer, Tosin, has done it. It uses some sort of a machine learning and also different algorithms for post processing, and that also has helped us. We don't really look at it as a threat, and people in the field, they don't really see that. We actually hope one day the AI and machine learning can help patent searching and eliminate some of the misrepresentation of the prior art that sometimes are misleading inventors and also examiners. So AI and machine learning, like radiologists and medical field, they're using AI for diagnosis these days, and it's been helping radiologists significantly. Sometimes they may get a noise, but they really know that that's not a tumor that they're looking at, and it's something else. But for IP, it's the same thing. An analyst can clearly just eliminate the noise and use whatever is needed, but that can help the analyst significantly. So it's not a threat, and believe it or not, it's being used as we speak these days, and we're using the technology ourselves.
It's complementary to like AI is complementary to the manual searching process. It's helpful.
Interesting. So I have another question related. There's an applicant who filed a USPTO application and received some comments from the examiner. Is it common or acceptable to request an online meeting with the examiner to discuss and clarify these comments in person or even virtually?
Online meeting, I'm not sure, but there is phone number, examiner's phone number. They can directly dial, and honestly, many times it happens when you call to examiners. It is really easy to resolve all the issues if they are resolvable. Like, let's say there may be some misunderstanding on some part, or maybe examiner is interpreting the invention in a way that's not they should. So if they clarify, and many times examiner themselves, they request, okay, here is a number, if you want to call, just give me a call and discuss. Yeah, it's a very common practice.
Interesting. And the numbers are available online, or it is like a specific.
Generally, when they provide the office section, like the comment, this type of, all these numbers are available on that particular document, email ID or the phone number, or if I'm not sure if the video conference is available right now or not. If that is available, that information also there. It depends on like what patent office, like which patent office are you talking about. If USPTO, US Patent Office, I am damn sure they generally just request the phone conversation. For Canadian Patent Office, phone conversation is available, but I'm not sure about the video conference.
Interesting.
Typically, the interview happens, and
Yeah.
they would rather, in one way or another, you'll do it. Even if they reject something, then you have the option to discuss that with them or
Yeah.
respond to the office action. So it's not really, you don't really know who your examiner is. It's, as Vivek mentioned, it's very transparent
Yeah.
um, process.
Yeah. And do you recommend for this case specific in general for this situation, do you think that it is more powerful for the applicants to have like an IP expert like you to discuss this rather than going as an applicant to discuss because maybe
Yeah.
right?
Yeah. it is actually recommended that talk to an expert, because obviously where is the gap? Like, let me explain you. So the inventors, they talk in terms of technology.
Yeah.
Examiners, they talk in terms of patent language and what the patent law is. So there should be somebody who can bridge the gap. So we consultant or IP expert, we are the bridge. So always talk to expert, answer the questions the way they want to listen. That's the recommendation.
I agree 100%.
The issue happens typically, for example, many individuals, they file their own SRAD strat, and if it goes well, you get the money back from the CRA. When you get audited, that's the time that you need an expert. With IP, it's a totally foreign thing, unless the person who's filed this has done it numerous times, knows the law, knows technology and all that. Chances are slim that they know all of it, particularly if startups startup founders, they're the first timer and they haven't really done this. So you definitely need at least to get some level of consultation from an expert. Otherwise, you may get yourself in a situation that you cannot really overcome that rejection. That may happen.
Yes, I 100 agree with you. It's whenever you have a case with the legislation, regulations,
Yeah, yeah.
government, you only have one shot. You either do it right from the
Yeah.
first time or you have you lose it. Yeah. So the other question is about Elevate IP. So anything related to Elevate IP in the email that I send after this session, we're going to have a lot of information about the Elevate IP and the duration. All the answers related to Elevate IP, you're going to find it in that email. The other question is related to business strategy versus IP strategy. You already covered that, Vivek.
Yeah.
So I think all the other questions already either covered, or maybe we can go for it. And I don't want to take more or step more in your time, Vivek and Siamak. So I would love to really thank you for this really informative and engaging. I'm going to tell you that most of our applicants, audience are still with us to the end, and this is not a common case. We usually lose people through the time, although we have extended 30 minutes. It was this if this means something, it means how much this was engaging presentation. So thank you
Thank
very
you.
much. I
Thank
have
you.
added all your communications in the chat. I will add more in the email after this session. We're going to go back to the presentation today in networking room.
Yeah. Yeah.
Please feel free to talk to Siamak and Vivek. And if you want to leave, even Siamak and Vivek, I totally understand if you have other commitments. Please feel free to leave the session. I will be staying around until the last person leave this session, and we'll take it from there. So thank you very much. I'm going to stop the recording now and go. We all go to the networking. Thank you.
Thank
Thank you.
you. Thank you so much for the time. Thanks.